The CPI report, Child Protection in Iowa, is brought to you by Vocal, Victims of Child Abuse Laws. You can you can see our program at 1 o'clock on Sunday afternoon. And also it's repeated again on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com, and we take phone calls from the parents out there, and we try to help on a one-to-one basis and give them our thoughts. Even though we are not attorneys, we have had a lot of experience in this issue. My number is 276-3956. John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. We're only too happy to offer hints wherever we can, and like Don was mentioning a moment ago, we don't hold ourselves out to be attorneys. We do have a few hints that may be helpful to you. I've noticed that some people, when they get these hints over the telephone, they're obviously writing very, very fast, and sometimes complain that they're getting too much information. Well, they really don't complain, but they're saying that they're getting overloaded. And I say, well, just give me a call back when you need additional information. Well, a lot of things are going to be happening in the next 100 days, because that's when the Iowa General Assembly is gathered together to determine how taxpayers' dollars are going to be spent, and what kinds of policies will be embedded in our system to run our various agencies and various facets of our government. I spent some time down on the floor of the at the state capitol, that is on the first floor, and we spoke to a number of legislators and others who happened by. And there are a number of concerns that Vocal has, and we'll be expressing those concerns not only in lobbying, but we'll be expressing those concerns from time to time on this program. One of the concerns that I had written up and was handing out had to do with giving children or assigning them to psychiatrists, psychologists, and therapists, and so forth. And so in a flyer that I gave out, it said it should be illegal for any mental health professional to perform treatment with a child suspected of being abused until there has been a forensic determination that abuse has occurred. If the allegation comes up inadvertently in the process of therapy, the therapy process should cease until the legal issues have been resolved, or, as Stephen Ceci suggests, supportive therapy could continue as long as it is not investigative in nature. And our Iowa shrinks don't, and our therapists and counselors don't know how to divide those things. In fact, they're only too happy to be in investigative mode at all times, and using the therapy route to get answers from children that they couldn't get in any other way. But treatment as a means of gaining leverage in a legal proceeding is contrary to ethics codes. Michigan protocol and good standards of practice, there should be adherence to the Michigan protocol and good standards of practice in every state. Ultimately, bad mental health practice makes horrible law. So what we're finding is that a number of children are being assigned improperly, with the assumption that because they're being treated for sexual abuse or for some other abuse problem, then that abuse must have taken place. And it's up to the therapist to make certain that they document and make valid that which is untrue. So, yeah, Don.
Uh, Parents are assumed to have sexually abused the children, and then you're saying that the children go through therapy based on that. We know that there's a lot of cases where the parents did not sexually abuse their children. Don't you think it would be a good idea to that the parents would have to be forced to go through a criminal trial to prove that they are sex abusers before the DHS can do this kind of work on children?
I'm not just sure how far we should take that route because certainly if they were found guilty, the children would be denied access to their parents, right? Because they'd probably be incarcerated if it's serious enough to bring about the charge.
Well, maybe. If they are guilty of a crime such as that, we're not here to protect parents from something they've done wrong. But anyway, that's just a thought on my part that DHS gets by with this without even having to prove that they're actually sex abusers.
That's correct. I think the main thrust of my comment here is that we put the kibosh on the use of tax dollars to send children to shrinks to validate allegations of child abuse, because there's so many cases where we've seen where those allegations are false, and you can get a therapist who's paid to do it to render a verdict to the contrary.
And they're not held accountable.
And not only that, but it's harmful to the child. And no one's held accountable to do that. And in the meantime, they're spending taxpayers' dollars without the support of wisdom in doing that. It seemed like to me that the only children that should be treated in these cases are children whose case requires the treatment. That's because they've been abused. So find that out first. Don't.
If the parents deny abusing the children, what right do they have to continue on?
Well, I think they assume rights.
Intimidation.
That's correct. And a judge can bang the gavel, whenever a social worker raises her indignant voice and says, do you want these children to have to tolerate further abuse here? These children need to be under the guidance of some kind of a shrink, of some kind of a psychiatrist, psychologist, a therapist or counselor. And I've even heard them assigning responsibility to one of those people to determine whether or not the parents even get visitation with their children if they're in foster care or out-of-home placement, which makes a real sad situation when people who can only justify their wages, their contract wages, if the child has been abused. So to me, it's counterproductive to turn something over to someone who will find you to be guilty in order to make a case, in order to make a buck. And to me, I think the main thing is, let's find out if the child needs treatment. Then think about treatment. In the meantime, we're wasting millions of dollars on treatment programs, and I think it'll be worse when we get nationalized medicine in here, because just somebody raising the voice and says, the child needs counseling, whether he's been abused or not, let's just send him to the counselor. Don?
We know in a lot of cases that parents are coerced into accepting that counseling and agreeing under threat, intimidation, in other words, from the social workers. So parents need to learn to stand firm. If they are innocent of what the system is saying they're doing, they shouldn't just cooperate with the system and say, okay, I'll accept that. In reality, that's what they're doing in a lot of cases, aren't they, John?
I've seen cases where they'll come back and assign the child to a therapist, and the kid draws a tree with his crayons, and they say, "Well, it's obvious the kid's been sexually abused. Look at the way he draws that tree."
Or smoke
Um,
coming out of a chimney. We
oh,
know
have
the
you,
child's been abused.
you've seen one like that, have you?
Well,
Yeah.
maybe that goes back 20 years ago, but
Yeah.
they do that.
Sure. Well, those kinds of things need to, those kinds of techniques need to be shunned, and certainly taxpayer dollars should never go to pay a counselor or a therapist or any of these other helping modes unless the child's treatment required. And by the way, I didn't say it in this part here, but a child should never be assigned to a guardian ad litem unless it can be shown beyond a reasonable doubt that, or at least at a fairly high level of competent evidence, that the child's legal interest differs from the legal interest of his parents. That's the only reason why you need a guardian ad litem, is if a child has an interest that differs from his parents' interest. But now they hire the guardian ad litem because you can draw the guardian ad litem close to the bench and say, "Look, lady, this is what we want you to do with this family. We want you to go and visit this child at lunchtime. Nobody else can visit him at lunchtime, but you can, and you can pull off things that the parents would never pull off themselves, so they can use the guardian ad litem as another warrior on their side."
How often
And
does the guardian ad litem go out and visit the children, John?
I've heard that they never drive past the house.
That's right.
um,
Why do they waste their time of day? They can make plenty of money without going to that effort.
Correct. Okay, moving quickly on to another concern. Should swift and meaningful consequences await those who thwart the best interest of the child? And I'm sure that our consultant here will help us out with that one because this is a broad and sweeping one. I'll tell you why. It's going to be very difficult to find the meaningful consequences and to inflict the meaningful consequences that thwarts the best interest of the child. Now, first thing we have to look at is what is the definition of the best interest of the child, and that includes but not limited to the opportunity for maximum continuous physical and emotional contact possible with both parents. Now, anything that is opposite of that, I think we should look at consequences to be invoked without setting up an entire court system to accomplish it. Refusal by one parent to provide this opportunity without just cause shall be considered harmful to the best interest of the child. That comes right from statute. That comes from section or chapter 598 of the code. And the reason why it's in 598 of the code is because it is in divorce situations where you find the best interest of the child is often neglected. How to thwart the best interest of the child. A separated parent, especially a custodial parent, can frustrate the expectations of the other spouse and the children regarding contact time. This is often done by often knowingly, willfully, and malicious in its operation. Excuses include the illness of the child, or the fact that the relatives are coming this weekend and want to see the children. Should the parent have consequences when they willfully withhold contact with the other parent? I think so. How are you going to do that without micromanaging the family and without building up the court docket? I really don't know. But I do believe that if the best interest of the child is paramount as a public policy issue, then its destruction or its harmful use should have consequences. If somebody wants to step on that notion, somebody should be stepping on that parent. Whenever a court steps on the best interest of the child, the parties should remind the court the potential impact on the children. Quite often, a bundle of accusation statements and child abuse reports are assembled in order to prompt the court to move in a direction which in turn diminishes the relationship with one or both parents. When this happens, any issue which rises must be thoroughly examined and dismissed in order to preserve the best interest of the child. The court or other authority can impose supervised visitation as a measure to frustrate the best interest of the child. Quite often I see that they use that to punish one or the other parents, when in the finality it actually punishes the child, because the child has that statutory requirement that he be given full access to both parents. Otherwise, his best interests are not served. Those who raise the unsupportable accusations must face consequences. If the best interest of the child is an appropriate and essential public policy, then public policy should be formed to assure the best interest of the child. What say you, Terrance?
Well, I agree with you. Anytime you have a body such as the DHS coming in and recommending a course of action which basically deprives that child of one of the parents, I cannot say in all instances that it is in the best interest of the child. You know, that's definitely not the case, especially under this definition that's laid forth. But a lot of times this is what we see that happens. I know of a lot of instances, I'm sure you know of tenfold instances that I know of, in which one of the parties was actually told to take a route that will justifiably in the minds of the court lead to one of the parties being denied their parental rights. I think one of the main cases that came to light just recently here, and I wanted to read this. I just thought it was very bizarre, but this is what goes on. This is from the Court of Appeals case in January 13th, filed by the Iowa Court of Appeals. Case number 04-882 of the Iowa Court of Appeals. And it doesn't state the party's name in a lot of these termination cases, just to protect the child's identity. In this case, and I'll state, a father appeals the termination of his parental rights to his child following a contested termination hearing held pursuant to Iowa Code Section 600A.7, 2003 of the Iowa Code. He contends the court erred in concluding termination was appropriate under Section 600A.8 and 5 for lack of payment of child support and abandonment. Now, again, no parties' names were mentioned, their initials. CJO was married to WLH when their child, ELO, was born April 1996. They eventually got divorced. They were granted joint legal custody, with the mother having primary physical care. CJO, the father, was ordered to pay child support and granted visitation. He last paid child support in April 2001, and he last visited with his son or daughter in May or June of 2001. The wife got married, remarried again, in June 2002, and then she filed a petition to terminate parental rights in 2003. Now, obviously, this is appears to me a financial move, because the court just stepped in and we can blame the legislature for this, because they do have a provision which says that the court may terminate parental rights where a parent has been ordered to contribute to the support of the child or financially aid in the child's birth and has failed to do so without good cause. Now, he contended that he had good cause because he did not have the resources to pay. Um, they found that he did, and they essentially just terminated his rights. They affirmed his termination. Um, I cannot and agree with this fundamentally, even if the law states that the court can do this, because as the definition states, a child cannot be in their best interest. Best interest of the child is including, but not limited to, the opportunity for maximum continuous physical and emotional contact possible with both parents unless direct physical or significant emotional harm to the child may result from this contact. I cannot conclude under that definition of best interest of the child that that was the case, that significant emotional or physical harm was to be resulted from this, from the father in this case. Now, he may have been a deadbeat parent, true, but depriving a child, innocent child, who basically has no rights, little to no rights, or no ability to seek out and to find their father, um, I think it's basically it's just completely and fundamentally wrong, and I think we need to address this to the legislature.
You're referring like to adoptees that they've had their rights severed with their parents, and they'll never get to see their parents again. Sometimes, a lot of times, based on false accusations. Uh,
Yeah.
Medical records are lost, or the courts won't allow the adoptee to see what could lay ahead for them, such as cancer. Does cancer run in the family? Diabetes run in the family? Sometimes it's nice to know ahead of time to get treated for something like that, or do something that'll keep you from getting it. And so actions like you're talking about just deprive a child from ever knowing these kind of things, let alone what little love they can get, or a lot of love they could get from that father. They've totally denied. Terrance?
That's incredible. Um, on a lighter note, I guess it's a somewhat lighter note. This is a story that came out of Lexington, Kentucky, from WKYT and Channel 27 in Lexington, Kentucky. Um, this is a case involving non-payment of child support as well. It may not have been what the court order he was expecting, but that's why Clark County judge said she did it, handing out an assignment as terms of a man's probation. He was in jail for not paying child support, but it's a late research paper that could land him back behind bars. When we were in school, nearly all of us have been faced with the prospect of a term paper that was due. Usually the penalty was for not doing your work was failing the class. But for a Clark County man, a term paper could mean the difference between jail and freedom. Douglas Mason got out of the Clark County jail just last Thursday, but not without an unusual provision of his probation. Under a court order, Mason must research and write a 5-page report to the court detailing costs associated with handling his prosecution for flagrant non-support. Clark Circuit Judge Julia Adams, my goal here is to first of all, try to make the defendant accountable, and secondly, for the defendant to understand that these costs are absorbed by the people of the Commonwealth. Once he understands the nature of the great costs incurred, it's my hope he will understand that I intend to see this through to the end. And Judge Adams says she's only trying to balance fiscal needs with judicial goals. The term paper is due on February 15th, and the judge did not say whether she would grade the paper on grammar and punctuation. I find that just bizarre is one of the big stories that are coming out of Kentucky, I guess, these days.
The reason why I mentioned this business of the best interest of the child is because so many of the telephone calls I get now deal with this area, and they say, they've tried 18 times to go and pick up the child for the weekend, and the children are sick, they can't go. Well, I'm sorry, but fathers know how to take care of sick children, don't they? Or grandparents are coming this weekend, and they're coming some distance. They want to see the children. Well, I'm sorry. Give the grandparents the schedule for visitation. Let them come on the weekends in which the children are with the custodial parent. There's 1,000 different reasons why parents want to frustrate the other parent because they can use this as a weapon, and some of these fathers are driving 380 miles round trip just for the privilege of seeing their children, and they don't get to see them, and they do the best they can to get the children back on time, see to it that they're taken care of well while they're on visitation. Of course, I hate the word visitation because how do you visit your child? To call that a visit is ridiculous. I think they're tending to call it contact now, parental contact instead of parental visit. And the word that gets to me more than visit is the word supervised visit. For what purpose is there supervision? Well, it's because somebody has raised some kind of an objection or some kind of an allegation that is often unproven, and even if proven, probably wouldn't rise to any kind of a level that would be necessary to deny the child his right to see the parent. The child is innocent in most of these cases, and the child should have the privilege of seeing his parent. Well, let's move on to another subject here. Just a moment.
One other thing I'd like to say on
Okay.
that before you do that, John.
Sure.
I agree with that. Provides a very convenient tool for a parent to abuse their desire to terminate the rights of a parent. It provides a convenient tool for a parent who may be very vindictive, maybe a disgruntled mother, maybe a disgruntled father. Either way, they could be disgruntled with their previous mate. It just provides a very convenient tool to get back at that other parent, and at the same time damage the relationship to the detriment of the child with the other parent. I just feel this is a horrible tool, terminating based upon financial means or the lack of the financial means thereof.
What that means is if we were to back that up to see if there's public policy, what it means is that if you're poor, you shouldn't have kids. Right?
Exactly. If you're borderline poor or poor, not no borderline at all, you are basically forced in a situation, it would seem, that you may have your parental rights terminated, and it's abhorrent.
You're poor, but make everybody else rich over your poorness.
Well, yeah, it looks that way.
Well, if you can spend it, the state can spend over $200,000 on each child, and the parent is kind of borderline on income. Wouldn't it be better just to give the parent a $1,000 check to make them not so poor, as to just make the social workers and the attorneys and the judges and the therapists all richer?
You'll
get paid.
you'll have to lobby on that one.
Well, I know they spend a great expense and a great amount of resources to pursue these cases. It kind of, to me, it seems it would be a lot more progressive and productive to have some sort of resources geared toward making the absent parent uh, financially be in a position to be more responsible and to try to foster that relationship with that child. Um, you could equally say that if you can spend $1,000, and I'm just throwing that number out there, but I know that the social workers are not cheap, and these offices that are funded by the state are not cheap to operate. But just say, for instance,
Let's
if a,
close them down then.
yeah, if a state and the attorney's offices and all these people that can combine to do something that's so detrimental to a child, so as to terminate their rights, and spend $1,000, it may be $2,000, maybe $5,000. This case went all the way to the Iowa Court of Appeals. I don't imagine it was cheap when you consider all the finances that went into it. Um, just say, for instance, if we put that money into getting the father or the absent parent, in this case it was the father, financially responsible, and give him a class on parenting and the needs of a child, um, and to try to foster that relationship back together. I think it would be to everybody's benefit to have a situation in which that occurred, rather than to go through and just do something so out of just totally out of logically keeping with that phrase, in the best interest of the child. To me,
Yeah,
I don't know.
Talking about termination of parenting rights brings back to my mind several years ago where this boy, about 12 years old, he was in foster home, and the foster parents fell in love with him, like happens a lot of times, so they filed for an adoption. Well, in order to adopt a child, first the parents have to have their rights terminated. So the 12-year-old, he knows all the knowledge of the court system, so he files. That's what it says. He filed for termination of parenting rights on his own parents. Well, what that means is an attorney prepared the paperwork and made the profit off of this deal, and so the boy gets what he is asking, or what he's brainwashed into asking for. Anyway, depends on how you look at it, and so that frees him up, and the adoption goes through, and he's adopted into this adoptive home. Oh, wow, that's great. But then in the news 1 year later, I happened to catch that it wasn't greener on the other side. He went back to his natural parents. So look at all the money that was blown by people pumping thoughts into that boy's head and taking control and filing termination of parenting rights and all those things. And it wasn't greener on the other side. And he went back to live with his parents. John?
Okay, moving on to another subject here, but we can certainly go back to the best interest of the child, because I think that prevails in all of our discussions with, particularly since our focus here is children. Were it not for the protection of children, we wouldn't need the Department of Human Services Protection Agency, and we certainly wouldn't need this program, would we? In order to boost that that particular element. So yes, if children are indeed the focus, the best interest of the child, I think, is absolutely essential. I don't know for sure how you would construct a method whereby those who promote the harmful interest of the child, the custodial parent, or even the judge who says that one or both parents are going to have supervised visitation. To me, that is an abhorrent ruling, to say we're going to punish these parents by taking their kids are reducing or diminishing their relationship to their children. I know of one father who got to see his child, if he drove to Omaha, some 80 miles either way, got to see his daughter 1 hour per month. Now, is that what you would call the best interest of the child? I think not. Particularly since he'd get to Omaha and find out that the child couldn't be seen for one reason or another. And he'd lose that month and have to wait till the next month. Those kinds of things handed down by courts, I think, should be stopped. I don't think that judges should be permitted to think in any other fashion than the best interest of the child, taking that into account. Well, let's move to another concept here. This is called centralized intake concept. Where did it go? $390,000 in tax dollars have been spent to investigate and to provide a proper protocol to handle 37,000 DHS telephone calls. The death of Shelby Dewis was Iowa's 911 alert to do something about a serious DHS system failure. It took DHS many months to own up to the seriousness of its work in Spirit Lake and across the state. The General Assembly commissioned a $140,000 study to find out why the system failed. The first of 48 recommendations was to implement a centralized intake system to handle the many phone calls in a more business-like manner. The current system is a sloppy hodgepodge of uncoordinated information which can be easily distorted or even lost. There are something like 24 or 25 phone calls alerting DHS workers to the dire problems that Shelby Dewis faced, but nobody bothered to handle those phone calls properly. The General Assembly authorized expenditures of up to $250,000 to implement a plan of centralized intake. Meetings were held, and lots of talk. But so far, no hint of a centralized intake unit has emerged. Apparently, the DHS has concerns of expansion which override a critical need to get the house in order. DHS plans more and more expenditures into such areas as community care projects rather than giving focus on the problem of child abuse as identified by the General Assembly, 3 decades ago. So the General Assembly, I think we have to say that they have done their best to give the DHS a kick in the seat of the pants, and to show them what they should do. The DHS has not followed through, even though they've been given the money to do the planning, and have failed to follow through to provide some kind of a workable protocol so that when 37,000 phone calls come in, those phone calls are not mishandled. The problem is this. Those 37,000 phone calls result in somewhere between 8,000 and 9,000 founded reports. What do they do with all of the other information that they're getting? You see, if this was handled by a separate unit, the DHS might not have immediate access to all that information, and they might not be able to get their foot into the doors of these other homes. They want more and more and more influence over families, and those 37,000 phone calls provide an enormous list of prospects for them to invade. The community care project is another one they can assign if they can't get a founded report on a family. Now they can put them under community care, or they can while it's the community care is a voluntary situation, they can get them under community care and watch them until they can hit them with child abuse. The whole picture for them is to get a broader and broader and broader grasp of the Iowa public, the Iowa families, and you can't do that if you go the efficient way, and that is through a centralized intake where you concentrate on child abuse calls and you handle them well. They're not interested in handling the calls well. They're interested in getting the numbers down, getting a good database, list of prospects that they can offer services to. And there's nothing in the statutes that permit them to do that. But they're using the child abuse statutes to gather the information and to expand their area of influence. So I think that we need to point out that the legislature wanted them to have a centralized intake unit. The Iowa Ombudsman strongly, after investigating these matters, strongly recommended a centralized intake unit. The legislature funded the $250,000 to study that and to bring back recommendations, but the DHS has failed to do that. Well, Don, you have a story that I thought was rather a clever one about DHS here and there, and perhaps we should take a look at that story, and then we should have you introduce Terrance Walker. Terrance has been with us for the last several sessions, and we're certainly pleased with his level of expertise in legal matters and his willingness to do some tremendous research. Don, let's see what your story has to say.
Okay, there's a picture of a man sitting at the campfire talking to some other people there. And there's 4 pages to this, so we're going to change papers here. This was written by Charles Meyer in the year 2001, and it comes out of Tennessee, but the thought is still the same. It starts out, gather around and let me tell you a story. This is a story of terror and fear and lies. You have all heard of Dracula and Frankenstein, of Jason and Freddy, and of ghosts and goblins you know are fiction. But there are real monsters that destroy children and families. There are parents who abuse their children. There are strangers who kidnap and kill or sell them. There are friends who help children destroy their lives with reckless behavior. But all of these, there is even a greater monster, one that does all these things and worse. This monster has puppets running around, willingly doing its bidding. We'll move the camera down here a little bit.
And it's called DHS, huh?
Down there it's called DHS also. You cannot see the monster because it is invisible. You can only see its agents. This monster has no conscience and tremendous powers. This is because it is a mindless, faceless bureaucracy. And like I said earlier, this comes out of Tennessee. This bureaucracy is set up to violate our most basic constitutional rights with impunity. No family is safe. If you do not have enough money for a real lawyer, you can be sure they will attempt to run your life to bolster their numbers for the next budget. They kidnap children and hold them against their will. They give no excuses or apologies. They do not believe in due process and our rights under constitutional law. They demand that our children are administered mind-controlled drugs like Ritalin. They set out to brainwash their young captives, trying to convince them that they are friends. They ignore the true needs of a safe and loving family and act upon groundless rumors and malicious accusations. They attempt to force children to become mindless slaves of the corrupt government. Next picture. The cowardice of the agents is legendary. They avoid real problems because it is easier to pick on the poor. Their agents, who work for this social parasite, make a middle-class income, exploiting the productive working poor. These parasites do not even have the decency to give these proud people the respect their lives and contributions demand. They complain and ask for raises, complaining they need greater salaries to live. Yet they attempt to give instructions to the working poor who earn their living at honest, productive work. These people assume no personal responsibility as they destroy their lives. They are never accountable to the children or families. They take over the position of father and attempt to destroy those whose love for their children causes them to reject their unwanted and unneeded help. This self-grandation with no personal responsibility and conscience is the nature of the bureaucracy in general. How can we teach our children moral values with this politically oriented and totalitarian institution undermining children's and parental rights? How can you teach your children individual responsibility with this interference? There are better ways and better institutions. In fact, I believe that that doing nothing may be better. Surely, DHS is one of the worst options. As I said, this is written by Charles Meyer from Tennessee. And let's go back to a previous picture. You can show that again, John, and then I'll drop another one in there. And then let's put a picture of a crying child. They don't take into consideration the feelings of the children. A lot of children, foster kids, are out there crying. They're being abused in the very system that the public thinks is set up to help them. Okay, John.
Okay, you want to introduce someone who's been helpful to us here in looking at court, particularly at issues of court, and we'll see if we can't get a good shot here of his name, and also of the fact of a couple of websites that you might want to jot down as you're introducing. Don, go ahead.
As you can read, Terrance Walker, and of course you've seen him already on our program this time around. Terrance is full of knowledge, and we appreciate him coming on the program to share his knowledge. Terrance, do you have something more to share with us?
Yeah, I just had some more comments. Thank you guys again for having me on the show. This is a pleasure. I do enjoy this. Believe it or not.
Yeah, I mean, you got to look at the funny side of life, even though it's not always good.
Yeah, there was a couple of things I did want to report on and wanted to comment on as well. As we've discussed before, there was a former judge of Muscatine County. It was an associate judge, Judge Weaver. He was 51. He was apparently had been he once had been convicted of driving drunk. I don't know if it was an OWI or DUI.
Are you saying a
Um,
judge was driving drunk?
That's what happened to him. Now, he was also arrested last year for doing the same thing.
The same
November
thing.
6th, yep, near Wilton, Iowa. Now
And if
this,
you caught him twice in the mousetrap, no doubt he's been around that mousetrap
yeah,
before.
well, this, according to this January 1st Des Moines Register article, he was granted permanent disability retirement after 2 drunken driving arrests and will work as a contract attorney representing poor defendants and juveniles. Now, I think that that really has 2 meanings there. Are these poor defendants because they didn't have any money? Or are they poor because they're going to have a drunk judge representing them? So, now, James Weaver, who's 51, according to this article, will be among 19 attorneys who can take cases in Muscatine County when state public defenders are not available. Weaver was allowed to retire with a permanent disability after the Supreme Court found that he suffered from major depression and alcohol abuse. He has 1 drunken driving conviction and was arrested again November 6 near Wilton. Police reports said his blood alcohol level was more than twice the legal limit to drive. In a December 7th report filed with the Supreme Court, a doctor said Weaver had tested positive for the chemical found in marijuana at least 2 or 3 times when he went to inpatient treatment for alcoholism and depression. State Public Defender Tom Becker said he signed the contract with Weaver because the former judge is still licensed to practice law. Now, now, I mean, I find it amazing that they bury these kind of statements or these kind of stories in the register on like page 8C or something like that. This should have been front page. I just find it to be very, very, very controversial. For the mere fact is that the Iowa Supreme Court, at the same time, Chief Justice Laverato, and there's been many, 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 many front page articles and opinion editorials on their supposed need for $7 million for the judiciary for this year. You know, Judge Laverato was actually put in a couple of the articles, and you know, they had this on the back burner. What we found out today, and maybe you can help share this with me, what we found out today is that this guy's 51, and since he's been a member of the judiciary here in Iowa for over 6 years, he's actually going to be allowed to retire for disability for being not only a drunk but also a weed head, looks like.
Well, what kind of a head?
A weed head, somebody that smokes weed, marijuana. He's smoking weed and drinking, and guess what? He's going to get, according to an official I talked with down at the State House today, he's going to get 60% of his income for the next however many years I guess this guy lives. So, you know, here we have one article, or 5 or 6 articles within the past 3 or 4 weeks saying how Judge Laverato needs $7.7 million for the judiciary this year, and for raises and for travel money and for all this extra money. Yet and still, this guy, James Weaver, will be getting 60% of his income.
Or $67,200 a year.
Yeah, if he's
for the rest of his life.
District judge, I believe district judges get $112,000. He might have got a little bit less than that because it looks like he was a county associate judge. Still, about 60 grand a year. You're looking at, if he lives to 91 for the next 40 years, that's going to be roughly $2.4 million.
Who pays that?
You and I and all the other taxpayers out there. Guess what? There's $2.4 million for you to spend for a guy that drinks and smokes weed. How about that? And as I was saying earlier, um, if we're doing wrong and we do something that it's breaks the law, it's called a crime. We're convicted. Um, Apparently, if a judge does something wrong, that's called retirement and retirement money.
Listen up, attorneys out there. There's a way to make a good retirement. Apply for the judgeship, and in a short time, apply for a disability.
And you could smoke weed and drink and even get more cases, more money. Or you could just retire.
Or as a story I read about a American attorney going over to Switzerland to teach on attorney work over there, and he said that here in America, you can get a lot of cases on people slipping on the ice on the sidewalk, and you can sue the landowner and make big bucks. So one of the attorneys over there thought a minute and raised his hand and asked a question about that, and he said, "I want to come to America." And the attorney said, "What is that? Why do you want to come to America?" "Oh, so I can slip on the sidewalk and sue the landlord so I can make big bucks." There's more money slipping on the sidewalk than there is being an attorney.
Okay.
Now, on a
Terrance.
related story, I found this kind of interesting. There was another story that came out today from Boston.com. Alleged drunk lawyer defends DUI suspect. Now, this is kind of the situation that James Weaver might be facing here. An attorney was arrested. This is in Pennsylvania. The attorney was arrested for drunken driving as he left a hearing for a client accused of the same thing, state police said. During Wednesday's hearing in the McKean District Justice's office, a state police trooper noticed Wayne G. Johnson Sr. might be drunk, said Robert Thompson, trooper. The trooper, who's testifying in a DUI case against Johnson's 20-year-old client, called at state police barracks. By the time backup arrived, Johnson was in his car, and Johnson failed sobriety tests and was charged with drunken driving. His blood alcohol level at his time of arrest was not available, but Johnson's receptionist said he had no comment. Well, I have some comment. This might be precisely the situation that the poor defendants might be facing here in Iowa if they're going to be represented by James Weaver. Did you have anything to say on this, John?
I think that's rather interesting that we have all these DUI cases in here. It's interesting to look over our judiciary, particularly since they want big fat dollars in addition to the $126 million they're already running to run that marble castle over there at 1111 East Court Avenue. I want to thank you for joining us on today's program, and we'll see you next week.